Injured in a car accident that was caused by negligence? If you have been involved in a car accident, it's likely that you would have heard the term negligence, particularly if you are suing another person or you may be sued. But what is negligence, and how can you prove that someone has been negligent? We're going to take a look at this now. What exactly is negligence? When someone has been found negligent, it means that they are thought to have acted in a careless or thoughtless manner, which caused injury or harm to someone else. Someone could also be found negligent if they did something that they should not have done, such as speeding. They could also be found negligent if they failed to do something that they should have done, such as stopping for a pedestrian. When driving a car, a driver should do what they can to avoid pedestrians, causing harm to other drivers, or to anyone else that they should come across while driving. If it is found that the driver is not careful, and they injure someone as a result of their carelessness, then the driver will be found liable for the victim's injuries. Aspects of a claim that involve negligence. The plaintiff, the injured party, must prove that the defendant, the person who caused the accident, had been negligent. Plaintiffs will need to show the following. The defendant was required by law to be careful. In many cases, the defendant is required by law to be careful when they come across anyone they meet when they are driving. This is also known as the duty of reasonable care. The defendant did not act carefully. Also known as violating or breaching the duty of care, a driver should have been sufficiently careful. In some cases, the law will compare the defendant's conduct with the conduct that will be expected of a reasonable person. The law will take a look at how a reasonable person would be expected to behave in similar or the same circumstances. If it is found that the defendant's behavior has fallen short, it will be deemed that they have violated the duty of reasonable care. Drivers are expected to stop at a red light, follow a vehicle driving in front at a safe distance, watch out for pedestrians crossing the road. The plaintiff was injured due to the defendant's conduct. If you were injured because of the defendant's conduct, you will need to show this. For example, David was injured when Simon's car drove into the back of his. David suffered from a shoulder injury due to Simon not paying attention. David will have to prove that Simon's behavior caused his injury. The plaintiff was injured or suffered losses. If you were injured in an accident, you could be entitled to compensation for your injuries, pain, and suffering, and any wages you have lost. If you did not suffer any monetary losses or you cannot prove that you were injured, you may not be awarded anything. If you have been injured, you will have to show that you were injured. It's vital that you, therefore, keep highly detailed records of your injuries, any property damage such as the damage to your car, and your medical expenses. What is a driver required to do? Every driver is required by law to drive with reasonable care so as to avoid harming anyone that they come across on the road. If a driver does not behave reasonably, the law may find that they have violated the duty of reasonable care. Here are a few examples of acting reasonably. Driving reasonably. Driving reasonably and at a speed that does not cause harm to anyone else. They will need to do this regardless of the weather, visibility, or how much traffic there is on the road. Keeping a lookout. Drivers have to stay alert and be vigilant whilst driving. They need to keep an eye out for any road hazards, pedestrians, and vehicles. They are expected to see everything that a reasonable and alert driver would see. Maintaining proper control of the vehicle. Drivers are expected to keep control of their vehicle at all times and should be able to stop at any time. If a car loses control and leaves or overturns on the road for no clear reason, they could be found negligent. Keep the vehicle in safe working order. Every driver is expected to keep their car properly maintained so it is in safe working order at all times. State law and drivers' duties. Every state has laws that govern how drivers are expected to behave when they are on the road. In some cases, if you violate a motor vehicle law, it is presumed that you are negligent. This means that the defendant must show that they were not negligent, as opposed to the plaintiff proving that they were. Conduct that may make a court presume you were negligent. Examples of the types of conduct are: driving on the incorrect side of the road, violating the right-of-way rules, driving while under the influence of alcohol or drugs, Defenses used in car accident claims. There are different types of defenses that are used in car accident claims that are based on the defendant's negligence. You should be aware that if you use some of the following defenses, you could completely erase your liability. This means that the defendant could lower the amount of compensation they will have to pay out. If you were involved in a car accident. If you were involved in a car accident and it wasn't a large one, you may be able to handle it without hiring a lawyer. However, if your accident was quite complicated or someone was permanently or severely disabled, you should consider hiring a lawyer.